We
All right,
are
so
now,
no,
we're recording now.
okay, thank you. So I'm gonna call the meeting to order, and Eric Fitzpatrick is going to provide us with some information about the criminal classification bill, which is a companion bill to the expungement bill that we did earlier this session. It's still in the I can't think of the name of the committee. Appropriations, my other committee. So Eric, if you want to do that, please. It's H580.
Oh, thank you.
Eric, you need to unmute yourself.
Thank you, Senator Benning. So good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as Senator Sears mentioned, to talk about H580, which is an act relating to establishing a classification system for criminal offenses. I'm sure the topic is familiar to everyone. It's been through the Judiciary Committee a couple of times already over the years. I think probably back in 2013 was when the Judiciary Committee and the legislature first created a criminal code reclassification working group. And it was basically, I think it was at the time, John Treadwell was still with the Attorney General's office, Matt Valerio, Dave Cahill, Robin Weber from the Crime Victim Research Group, and Judge Morris were the 5 members of that group. And they, with the entire idea of a classification system, just to refresh your recollection on that for a second, you know, I'd say not all, but the majority of states in the country, you classify their criminal offenses according to, for example, say 5 different levels, usually denominated by a letter. So it could be, for example, a Class A felony, a Class B felony, Class C felony, similar Class A misdemeanor, Class B misdemeanor, etc. And then there's something in the statutes that will say, here's what the penalty is for a Class A felony. Here's what the penalty is for a Class A misdemeanor. In Vermont, by contrast, as I'm sure you well know, each criminal statute has its own particular penalty embedded in the statute itself. For example, it might say, you know, a person who commits manslaughter shall be imprisoned not more than 15 years and fined not more than $10,000. Now, each one has its own individual penalty, and it's been developed over the years. Each time you add a new offense, we look at, you know, what the appropriate penalty is. But there isn't this overarching classification system that organizes everything into these different categories that many states have. And that's what the judiciary committees have been thinking about doing for several years now. As I say, the working group first started in 2013. That working group recommended a 5-tier classification system, but it didn't yet decide which offenses should go in which category. And the legislature realized that that was a substantially work-intensive project. So it tasked in 2018 the Sentencing Commission, which already existed, although it had been dormant. I think there was a small appropriation given in 2018 to the Sentencing Commission to get restarted and to look at the classification idea and think about which offenses should be categorized into which category. So that's what the Sentencing Commission has not completed that task yet, but they've started on it. And that's what you have in H580 is the beginnings of their recommendations as to how to put this classification system into place. And the House Judiciary Committee made a couple of changes to what the Sentencing Commission recommended, but for the most part, what H580 reflects is what the Sentencing Commission has recommended as the system to put in place to get started. The easiest way, and sort of the obvious question is, all right, what are these classifications that are proposed to exist? And I had Peggy put up a document that I think might be the easiest way to look at that. It's a chart, and it's called the comparison between the House bill and the Sentencing Commission recommendations. It's under my name, called Differences Between House Bill and Sentencing Commission Recommendations is the chart. And that's the easiest way to see what the categories are. I don't know if that's available to everybody, or is it something you can
Yeah,
pull
it's
up?
on it's on our committee website. I
Oh,
don't know if
perfect.
Peggy can put it up or not on the screen. But I've got it. It's,
It's from the committee webpage. You can see it, Senator Sears?
yes.
Oh, great.
So either people that have that available, or Peggy could put it up on the screen if she's here.
Okay. So I'll review those real quick. So you can see there are 5 categories each for, oh, thank you, Peggy. You can see there are 5 categories each for both felonies and misdemeanors. So A, B, C, D, and E, both for felonies and misdemeanors. And so the felony category starts with Class A. That's the most severe penalty, and that's the maximum penalty, any offense with a maximum penalty of life imprisonment or a $500,000 fine. So those would be your Class A felonies. And you'll see also there's a comparison that shows you if there's any differences between what's in H580 and what the Sentencing Commission had recommended.
Eric,
Yeah.
before we go any further, just I acknowledge this is an ignorant question, but a $500,000 fine or $1 million fine, what is the utility of that? I mean, if I imagine that no one ever pays off said fine, what is the function of $1 million fine?
I think it's viewed as both, there is some degree of, I think you're right, that the vast majority of defendants simply don't have the resources to pay those kind of fines. But occasionally some do have the resources to pay some. And I think it's sort of, in some sense, there's a history to it in that criminal offenses both have a period of incarceration and a fine attached to them. It's just, in many ways, that's historically always been the case. But also there's, I think, a view of deterrence potentially involved, retribution. You sort of talk about the general policies behind criminal penalties, and there have been many studies as to whether any of these functionally work that way, but certainly a retribution sense, which basically means punishment, right?
Yep.
Deterrence, or any sort of effect of deterrence upon the penalty on the potential criminal defendant's conduct. I think those are sort of viewed as.
But someone can't pay the $1 million and then evade prison time.
Correct. Yes, you wouldn't be able to sort of buy your way out of prison, no.
Right. Okay. So I understand the historical argument, but all of our discussions around fines have been around the other end, that we wind up in situations where people we would like to let go still owe fines, and we're trying to make up this potentially lost revenue. I'm just wondering, if we do an entire reclassification, but we put in place what are essentially fictitious amounts. I mean, $1 million fine for someone or a $500,000 fine, it just seems out of touch with reality somehow. So I'll just offer that and we'll go on. But yeah, I can't imagine anybody ever satisfying that part of their sentence. So, Senator Sears, is that
It's probably correct. I think sometimes that the legislature, in drug trafficking crimes, we've put up some pretty high numbers, assuming that you actually got at a person who was a chief. Usually we get at people who are rather low income and not able to afford those. But I always think of Bernie Madoff, that type of crime. Although he didn't murder anybody that we know of, but certainly.
Although I believe his son killed himself.
That may have been, yeah.
In any event.
Yeah, I think the point is well taken, that sometimes our fine structure I always found to be pretty tone deaf to the actual wealth of the individuals who are usually, involved in those crimes, except those white collar crimes, as well as some of the drug crimes, certainly. Frequently, there's quite a bit of money involved.
Okay.
Alice?
I'm just wondering, so, I mean, maybe you're going to get into this, Eric, but does this mean, so say this is adopted in Vermont, does this lock the judge in on exactly what these things are? They can't do something creative?
No, it just sets a maximum for any given offense.
Right.
In a sense, it's in that conceptually, it's no different than what we have now.
I think
Every offense has a maximum. It's just
Correct.
that there's no uniform organization to what those maximums are. So it's
Correct.
Sorry.
Correct me if I'm wrong. This is sort of an attempt. We currently have things like listed crimes, the Big 12, et cetera, that we often rely on. Is this an attempt to move us where we have various classes of felonies where people who are convicted of those certain felonies may or may not have different? Is that what we're trying to do?
I think, although this bill doesn't
I'm not
get
sure
there,
what it tries to, what is it trying to get to? And I think that's the question that Senator Nick is, and I have as well. What's the goal?
I think that's a question you really need better asked to the sponsor. But I think, from a legal perspective, the strict organization of these felonies into categories is the goal. And I think some of the practitioners in the criminal defense area testified in the House that there's a geographic justice element to this and a predictability element, that with more standardization of penalties, that the actual, because there's a difference between the statutory maximum and what actually gets imposed on a particular defendant. So I think that some of the thought had been that the wide variation in the potential penalties without some sort of standardization across categories means that there's less consistency in the actual sentences that people get. And I think that's probably the best I can phrase what I think the goal is. Some sense of predictability. I don't know that criminal defendants are necessarily calculating what their potential incarceration might be before they act. but I think predictability for the practitioners in the criminal defense field, prosecutors, defense attorneys, judges, that sort of thing.
Right.
But it's another good point that you were getting at too, Senator Sears, is that, and this is a very important piece of this legislation, is that the effective date is not until 2022. It's got a 2-year out effective date. And the reason for that is, as you look at this chart of categories, you think about it, there's 900 plus criminal offenses that we have on the books right now.
Mm-hmm.
This bill does not, and if you're going to decide, well, the next step in this, and it's not done in this bill with the exception of the property offenses, which is the one place that this has been done in the bill. But the major task is going to be going through all these offenses and deciding, well, which category should it go into, right? That's the big, you can set up the categories, but then the big work product is going to be, all right, we've got these 950 offenses, which one should be Class A, Class B, Class C, et cetera. And that is the reason that you have a 2-year out effective date of 2022, because the categories are set up in this bill, but it does not yet place the different criminal offenses into a particular category. And that's something that presumably the Sentencing Commission is going to be doing over the next couple of years.
Senator Baruth has a question or a comment.
Maybe another dumb question, but why wouldn't we wait until we can pair the categories with the offenses?
Yeah.
Another excellent question for the sponsor. I will add that my perception on that is that the idea was that it gets the ball rolling, gets the momentum moving toward the establishment of the system, and that with this sort of first step on the books, kind of, in some ways you could look, it's sort of comparable to the idea of a sunset sometimes. You know, the idea of a sunset is that it forces the legislature to take another look at it in a couple of years to act again. Maybe that's a good analogy, in that the idea was put this on the books for now, sort of puts the boots in the ground, as it were, on the ground. And that way it's almost like you've got the skeleton in place and then you hang the rest on it when it comes out over the course of the next year.
I think if we can save, and now I have another question which you raised with this, Eric, and so our list of questions for the sponsor, Representative Lamont, will grow, but if somebody can keep track of them so he's aware of that when we invite him to join us. One of my questions is, under justice reinvestment, we're looking more at a risk-based than offense-based system, and this seems to move us in an offense-based system rather than a risk-based system.
I think that's right. It's offense-based. Yep.
And that may be counter to what we're trying to do in the overall scheme of criminal justice reform. Just another question for the sponsor. So thank you we try not to shoot messengers here.
I appreciate that.
So continue your message, please.
What was just so I can remember too, because I don't want to forget, what was I know, so we have the risk-based versus offense-based comparison, and then the
corrections department and justice reinvestment, I think, leads us more and more to a risk-based criminal justice system, so that people who are high risk are the ones that are incarcerated. People that are low risk would not be. Sometimes the crime is such that you have to have a period of incarceration, but they may be, in fact, low risk to reoffend.
So the three questions that I've noted so far are, what is the purpose of having this system in the first place?
Yep.
Number two, why do it now when the Sentencing Commission hasn't finalized its recommendations for what offense goes into what category?
I think Senator Bruce's point is, why do it when we don't know what the crimes are that why wouldn't we fit the crimes in to the categories?
Yep. And then you've got the justice reinvestment comparison piece.
Yeah.
Yep.
Which is more risk-oriented, risk-based, trying to establish that. And here we are labeling people as a Class A felon. I know in New York State, they have sex offenses, Class A, B, and C, I believe. And I have this constituent who's always telling me that so-and-so is a Class A felon, sex offender. And sorry, there is no such thing in Vermont. But
right. All right. I've got those questions noted, though. Thank you.
Thank you. So if you want to continue on with the kind of the chart.
Yeah.
I think we were at the Class C felony.
Yes. And you can see as I think both you and Senator Bruce were pointing out as well on the fine issue, that the House bill does knock the Sentencing Commission fine recommendations in half for the most part. 50, on the Class A, for example, Sentencing Commission recommended $1 million fine. They went down to 500,000. The categories for felonies are life for Class A, 20 years for Class B, 10 years for Class C, 5 for Class D, and 3 for a Class C felony.
Well, maybe the question number 4 for the sponsor would be, why have fines at all determining? Shouldn't it be the maximum term of imprisonment? Because the fine for drug trafficking, the drug trafficking statutes have rather high fines, but may not meet the life imprisonment.
Part of the answer to that, Dick, though, might be where do these fines end up? If they're supporting the victims' advocates in any way, shape, or form, that might be a whole other part of the equation.
I guess why bother with why bother with fines as part of our classification system?
Because they're not paid very much, that sort of thing.
Yeah.
Yeah.
Right.
Right.
Clearly, you know, a guy with a $25 bank account's not going to be able to make a $500,000 payment of a fine.
Right. Yeah, I noted that one too. Thank you, Senator Sears. You'll see as you move into the misdemeanor categorization that the line between a misdemeanor and a felony is preserved. It's a 2-year, exactly the same as it is in existing law. So if it's a 2-year maximum imprisonment, then that's going to be a Class A misdemeanor. And then it goes down there from 2 years to 1 year for Class B, 6 months for Class C, 30 days for a Class D, and no imprisonment. Because we have a bunch of offenses on the books that are fine only, and they would fit into your Class C misdemeanor category. The idea for attempts, right now attempts are punished in the same manner as the underlying crime. In other words, whatever the penalty is for the underlying crime, an attempt is generally punished the same way. The proposal here is to make each one a Class C felony, which in the category for that is a 10-year imprisonment. Sorry, but it could be, it either would be that or the punishment for the underlying offense, whichever is less. So.
Wait a minute. I want to make sure we're talking about attempted murder being a Class C felony.
Not only if the yes, I think that's right. Whichever one would be less.
Well, given
So,
all the, and I want to get the right term regarding Jack Sawyer, all the angst, community angst about charging him with an attempt and our attempt statutes. But the one thing that people relied on was an attempt is the same as an actual, in terms of a possible sentence. Are you saying that if we change this to a Class C felony, the punishment would be 10 years, no more than 10 years for an attempted murder? Not you, as the sponsor saying.
well, the House, yeah, yes, but yes, that's right, Senator Sears.
So I think that's a real, I can see that being people wondering why they did that.
Yeah.
If that's really what would happen.
Right.
I know we had that whole argument about whether what he did was actually an attempt and Vermont's laws regarding attempts, but we attempted to change the laws regarding attempts and were unsuccessful in changing them, as I remember. And part of the comfort level was at least it was the same as if you had actually completed the crime. So
Right.
I would say that's another question for the sponsor.
Yeah, I noted that one too.
Mm-hmm.
So that takes us through the chart. There's only a couple of other points I wanted to hit, but we don't need to look at, well, it's good to keep the chart up actually, because sometimes you can bounce back and forth. But a couple of other points to note are the bill, as I say, although for the most part, it doesn't put the long list of criminal offenses into a particular category. It does do so for property offenses. That's one of the substantive areas that they did get, and there's about 45 different property offenses, and that's the bulk of the bill actually. Most, you know, I think it's a 38-page bill or something, and about 34 pages of that is just going through all of the property offenses and making a determination as to which category that they go in. So in that section of the criminal law, the property offense section, the work of deciding which category to place each offense was done. And that's, rather than go through each one of those here, I think it's just helpful to note that that's what they were done. They were categorized. Another point I wanted to make is that because of the fact that it says a 2-year, it's not effective immediately, but goes into effect on July 1st, 2022. The bill has what's known as transitional provisions, and those are on page 3. And that's because it may be that since it's unclear at this point when the decision will be made with respect to the vast majority of these criminal offenses about which category to put them in, this sets up some transitional language that says what happens in the meantime. In other words, between now and then, how will offenses be treated? So if you look at, for example, on page 3, and this is section 54 of Title 13 was where it would be placed, you'll see that the language provides it unless otherwise provided by law. In other words, if the legislature has not yet passed a statute or passed an amendment to a particular statute saying what category it goes into, for example, as you were indicating about attempted murder sentences, if there hasn't been a statute yet that says murder shall be punished as a Class A felony, that hasn't been done yet, well then this provides you with some language that would be in effect in the meantime. So it says under felonies, for example, any felony punishable by a maximum term of life shall be a Class A felony. So that just provides you with something that would be in effect during this 2-year period while the Sentencing Commission is presumably doing this work to categorize all the offenses.
But can
You'll
I
see
ask,
Yeah.
Eric, let's say that we were to do that
Yep.
and someone is convicted during that 2-year period. So they're convicted of a Class C felony, and then we decide in the final reckoning that that should be a Class B felony. Wouldn't that cause lasting confusion?
Well, remember during the first 2-year period, this won't be in effect yet because it doesn't go into effect until July 1st, 2022. But nevertheless, the situation you described could still happen. Like let's say this does go into effect on July 1st, 2022, and the Sentencing Commission hasn't completed all of the categorization yet. So the fact pattern you described could happen in that situation where somebody gets convicted of some offense that's under this categorization would be a Class B felony, but later on it's become a Class C. I think that the courts could work with that because it's not unusual for that to happen even now. Sometimes the legislature changes the penalties for offenses, and that has resulted in litigation sometimes to determine, well, which penalty applies. But generally speaking, the penalty that's in effect on the day that when the offense was committed is the one that applies.
I guess
now it's true.
I go back to the simplicity principle. What the sponsor is asking us to do is, quote unquote, get the ball rolling. So to put these into place, put transitional language into place so that we can do something now. But as far as I can tell, there's no harm to be incurred if we don't put this into place and just wait until we have the entire scheme. That way we don't need transitional provisions. We keep what we have in statute, and then we make a systematic overhaul at a later time without the possibility of the fact pattern we were just discussing.
Yeah, that may be our amendment.
Okay.
Maybe not exactly as just worded, but I think it makes eminent sense that if you wanted to pass something and we were to agree with their attempt at putting all property crimes into X category, then that might be a start. But to try to attempt to say in 2 years we're going to know what Class B felonies are and what Class C felonies are might be difficult. Well pointed out. I don't necessarily oppose the idea of a criminal classification system, but I worry that that the way this is laid out without knowing what the crimes are yet could have unintended consequences.
On that same point, just another thing to alert the committee to about the transitional provisions is, and again, in theory, the transitional provisions may never need to go into effect, right? Because if before 2022, the Sentencing Commission finishes all the categorization, they can come back to the legislature and say, we've got the whole thing done. We'll have this go into effect instead of this bill because this hasn't gone into effect yet. See what I mean?
Yep.
So that's the theory. And the one point to note, if all the offenses aren't categorized by that time, and this does go into effect, another, you'll have to be, if you look at the transitional provisions, for example, subdivision B, 1B under the felonies, says all felonies punishable by a maximum term of 20 years or more, but less than life, shall be Class B felonies. I mean, a Class B felony is a 20-year term. But, you know, not every existing offense fits neatly into these categories until the final classification is made. So let's say you had an offense that was a maximum term of 25 years. And someone gets convicted of that before the final classification statutes have been enacted. Well, then the way A and B work, if someone's got a maximum term of 20 years, but less than life, so that would be 25 years, right? 25 is more than 20, but less than life. Yep. That would be rounded down. That would be a Class B felony, and that would be a 20-year max, which should be a 5-year reduction in what the statutory maximum is. Everybody follow that?
Yep.
So anything that doesn't neatly fit into one of those categories, because the net for C, it's a 10-year. So in other words, a 15-year one, for example, doesn't fit in. The sort of the default is to round them down during this transitional period. Again, that may not happen because ideally the Sentencing Commission gets all this done before July 1st, 2022, and you can put that into place and this never goes into effect, but just something to be aware of.
Thank you, Eric.
Yeah.
I think we're going to transition over. I know you've got to go somewhere else. Right. Well, actually, you're not physically going somewhere else. You're electronically
right.
going somewhere else.
That's
we're
right.
not allowed to.
I know. I feel like I was saying I have to go upstairs, but I'm not really going upstairs now.
No. This brave new world of Zoom and other stuff, it really is overwhelming, and I'm still trying to respond to the diaper request.
Oh, God.
What is
Have you
the diaper
responded
request?
to the diaper? I guess it's just for those of us on appropriations. A certain group wants to get funding for diapers.
Oh.
And I'm overwhelmed and hadn't gotten back to them, and now I'm getting these emails that I must have missed their email.
I had no idea where the diaper request was going.
It's a certain group actually in the Champlain Valley that is providing diapers to families. It's not a bad thing. Don't get me wrong. It just
There's a whole lot more about this particular bill that is going to require a lot of discussion. I was reading through some of the provisions, and in one instance, they've created a organized retail theft bill that if you create an act of theft with someone else within a given time period, I don't know why the time period's in there, but the way they get classified depends on how much they actually stole in retail value. And I don't know how they came up with that concept. If I break into Littleton Coin thinking I'm going to get $1 million, but I'm only successful in breaking into the glass case that has quarters in it, I'm classified differently for the amount that I'm removing, even though the overall act was my breaking into the place with somebody else within 180 days.
Well,
It's little things like that that are going to leave people like me confused on how you approach this dealing with clients and with state's attorneys trying to resolve cases. So I'm only floating that one example out there, that there's a lot more to this bill than just the classification itself.
Well, I can't wait to hear from Representative Lamond.
Well, on that point, that's actually, Senator Benning, that was the one last point that I wanted to make before I left, because you're right that is the one in the entirety of the bill is all about reorganization, except it creates one new offense, and it's the one you just named, organized retail theft. And the idea behind that is that evidently there was testimony that for shoplifting offenses, that defendants were intentionally shoplifting up until an amount of goods that would only go right up into the amount that crosses over into a misdemeanor, which is $900 currently. And remember that when we went through the property offense distinction years back, the legislature settled on $900 as the threshold between a misdemeanor and a felony. So there's been evidence that defendants are shoplifting, $850 worth of items in order to only be prosecuted as a misdemeanor. And the idea behind the organized retail theft is if you can show that it's part of a sort of a joint enterprise, it's all part of the same action, that it can be prosecuted as a felony. That's the theory.
You know where that's going to end up, Eric? That will end up as an essay question on the bar exam. Some poor slob to explain.
Right, that's true.
I can't wait to talk about organized retail theft. I'm just thinking about where I live. So you go to Williamstown, Mass, and you steal $850 worth, depending upon what the limit is in Williamstown. Then you go over to Hoosick Falls and you steal $850. Then you come to Bennington, steal $850. It's 3 different crimes, but it's not organized because they're in 3 different states, and you've only traveled about 26 miles.
Right.
I think if you do it by yourself, it's not organized. Is that?
No,
right?
I think it is organized.
No, I mean under this bill.
I don't know. I didn't read that part, Joe. You're way ahead of us.
Now, the real question is, can people be charged with conspiracy if they didn't actually pull off the retail theft, but they did one intentional act?
Possibility.
You might want to have Martin Lamond on for quite a while for testimony purposes. This is going to be fun.
I'm sure he'll be looking forward to it after he sees this YouTube. All right. Thank you, Eric. Head upstairs, wherever it is you go to move from one meeting to another.
Yes, they're taking up S-183.
Now Michelle's coming downstairs to be here.
Right. All right. Well, I'll move on upstairs then. Thanks, everybody.
All right. Say hi to everybody upstairs.
I will.
Michelle, I think we have Dr., and I don't want to mispronounce her name, but Dr. Gaetan. Well, I did my best effort. Welcome to Senate Judiciary Committee. I want to make clear that today we're dealing with the bill H-936, which has to do with the sexual exploitation of children. We are not dealing with H-568, which is the human trafficking and prostitution bill that came out of the House. I don't know if we're going to take up H-568, but if we do, we will certainly hear from all the people, or at least a representative group of the folks that I heard from very concerned about what the House passed. And I think this committee shares their concern, particularly about the sex working group and some of the other provisions of H-568. We did have our own bill on human trafficking that I think is the right direction to move in. But given the controversy that has enveloped H-568, I'm not even sure we're going to take it up. It's very difficult to deal with certain bills in this new world of Zoom. So anyway, I hope that, and I appreciate your being here to give us a national perspective on this issue of child pornography. We heard testimony yesterday about how it's expanded because of the pandemic and people being at home and more time on their hands, I suppose. And so we appreciate your being here. I know you have someone else who's also listening in, and well, again, we're welcome to have her comment, but I don't want to get into 568 today.
Absolutely, Mr. Chairman, and we appreciate so much your welcome attitude towards subject matter experts who have experienced this crime personally.
So I had originally scheduled Michelle. I think I'm going to have her come after your testimony as we begin to mark up the bill following your testimony.
Thank you so much, and good morning, Chairman Sears and members of the committee. My name is Eleanor Kennelly Gaetan. I'm Director of Government Relations at the National Center on Sexual Exploitation in Washington, D.C. We're a nonprofit, nonpartisan, founded in 1962. I'm also active in New Englanders Against Sexual Exploitation. That's the backdrop I have here. It includes Vermonters, and it was Nice that requested Nicosi's Law Center to analyze H936, an act relating to sexual exploitation of children. Having grown up in Connecticut, where I still have extensive ties and property, I have some of my most precious memories of skiing in Killington and Stowe. Your state is a real wonderland, a treasure for those of us who visit. I did hope to be joined by a colleague, Tricia Grant. She's the founder of If Only One. She lives in Maine, but she was a victim of sex trafficking and exploitation in Vermont at age 15. And hopefully you'll have a chance to hear from her in the future, especially if you move forward with this bill. And I apologize for not getting prior permission for her, and she has left the call. So Nicosi commends the Vermont legislature for opening up your state law regarding the sexual exploitation of children to reflect current understanding of the nature of this abuse. Across the country, we are seeing changed legal terminology. We're seeing states change from the old phrase child pornography to child sexual abuse material, or CSAM, in order to reflect the tragic reality that every instance of child pornography is documentation of a crime. And it's a crime with lifelong negative consequences for the psychological and physical well-being of the child victimized in that photograph or video or digital record. Last year, NCMEC, and that's the National Center on Missing and Exploited Children, the lead agent of government nationally on this crime, they wrote a report last year that really makes clear the focus that should be on the victim, the pain, this experienced by the victims of CSAM. That report was captured on film. Survivors of child sex abuse material are stuck in a unique cycle of trauma. So H936 adopts this new term, CSAM. It also includes 3 other improvements that we would like to highlight. It broadens the scope of CSAM by adding terms like available and file sharing or peer-to-peer networks. That updates the way CSAM is typically exchanged through file sharing on peer-to-peer networks. The proposed bill also adds language knowingly access with intent to view. This is broader than just possession. It would include looking at a video and not downloading or storing it. That's a good improvement. And it broadens the scope of the crime by adding language with or on instead of just conduct by a child. So the law will read conduct by, with, or on a child. What concerns Nicosi is that the improvements made by H936 simply do not go far enough to strengthen Vermont's statute in order to protect the people that the term CSAM seeks to highlight, the victims. The bill is like a person going out to a playground in order to make it safer and seeing a hole in the slide or no guardrails, glass on the playground, and planting some flowers. Please allow me to highlight 4 major weaknesses in Vermont's current CSAM statute, which would be strengthened by, could be strengthened by a more comprehensive reform. First of all, H936 retains Vermont's existing definition of a child as under age 16, while of course federal law on CSAM applies to minors under age 18. as does the law in neighboring Massachusetts, for example. There are only 5 other states in the nation which fail to protect youth ages 16 and 17. Those states are Connecticut, Maine, Maryland, Nevada, and New York. There are 2 states, Alabama and Louisiana, that define children as under 17, age 17, for the purposes of their CSAM statute. Nicosi believes that youth ages 16 and 17 should be protected from a form of sexual abuse that causes deep and long-lasting psychological and physical harm, as 42 other states agree. Second, H936 retains a mistake of age defense for recording CSAM. It retains the mistake of age defense given to perpetrators for use of a child in sexual performance. And then fourth, H936 could add a problem to Vermont's statute. It adds the term simulated conduct to the definition of CSAM. That term could be considered unconstitutional in light of Ashcroft versus Free Speech Coalition, which found, quote, virtual child porn, and quote, be constitutionally protected. Overall, the flaws in Vermont's current law are not remedied by the small improvements made by H936. The 2 versions of affirmative defense in your statute remove responsibility for due diligence from the defendant. That's bad policy that prioritizes and protects the accused over the child who was sexually exploited. What Tricia Grant's main point would have been is that when she was a 15-year-old trafficked into Vermont, no sex buyer, no pimp ever asked her age because they don't care. And therefore they shouldn't be allowed a pass because they suddenly didn't know how old she was. And it is usually a shame. Also, prosecutors face challenges in meeting the burden of proof to establish that the perpetrator had prior knowledge of the age of the child. So such a defense serves to shield exploiters while increasing the burden on prosecutors. Every year, there's an excellent group, Shared Hope International, we work with often, and they publish a state-by-state report card. They look at child sex trafficking. They also analyze child sexual abuse material statutes. The 3 components are obtaining CSAM, creating and distributing CSAM, promoting and selling CSAM. According to the most recent report card, Vermont got a C on its overall legislative approach to the sexual exploitation of children. Vermont has only raised its grade once from D to C since 2011. So Nicosi urges you to set aside H936 in order to do a deeper, more meaningful of the statute, an effort that Nicosi would be happy to contribute ideas or language to. Thank you so much for this opportunity. And I want to especially thank Ms. Delaney for her great efficiency in managing these hearings so well and being incredibly fast and weekend accessible for those of us that hope to share our organization's opinions and ideas with you. Thanks a lot.
Well, thank you. I do appreciate it. You raised several issues. The bill was actually, the genesis of the bill is concern from the Attorney General's office about changes that have had, and we did have a conversation, and I believe we'll have a conversation shortly about the issue of simulated conduct and possible unconstitutionality of it. We've been working, Michelle has been working with the Attorney General's office as well as with the Defender General's office to see if we can't deal with that. I would be concerned about putting this bill aside personally. However, that doesn't mean we couldn't continue to work to improve the laws in other efforts. And again, we worked, I don't know if you know James Dold. Have you ever met James? He works with a similar group, and he was the genesis of the bill that I introduced earlier in the session, dealing with human trafficking. And he used to be with the Polaris Project. So I don't intend to leave this here as long as I'm in the legislature, and I think as long as this committee is active in protecting kids. I'm fascinated by the the issue that you raised regarding 16 and 17-year-olds. And we've done that because the age of consent in Vermont is 16 and 17 are able to consent. I'm not sure how that works in the other states like Massachusetts. I'm not sure of their laws, but maybe you could help me a little bit understand how that would work if the defense would be that they were over 16.
Let me look at that and get back to you by email.
That would be helpful. Senator White has a question or comment.
Thank you, and I apologize for coming in late. I think the issue that you raised about the simulation and with the Ashcroft case, I think we heard yesterday from our Attorney General that because of the way the whole law is structured, that it is clear that there has to be an actual child involved in anything. So he felt that it did not, I think added some language there. Michelle added some language there to clarify that.
Good.
Okay. Other questions for Dr. Guta? Gonna have a hard time with that. Okay, I would have a couple of questions about mistake of age. That does sound like, it's sort of like, how do you see that as the defense in this bill? How would you rectify that? Do you know, Michelle, how would we rectify that?
Oh, I'm sorry.
The defense of age, mistake of age, and
Right.
that the doctor has pointed out.
I don't know. I would need to to take another look at that because we haven't been dealing with that particular issue. And I think I'd want to hear from the AG's office and the Defender General's office about that. Because I think one of the things that you're wanting to make clear in, like, if we're looking at the language that's in the proposal now in the bill is when we're talking about, we were talking yesterday about one of the issues around what if somebody downloads something with the, that you want a knowing aspect to that. So you don't want kind of by mistake people to be caught up in things. And I think if you don't have, I think we'd want to explore a little more about, if there's not the ability to raise a defense regarding mistake of age, what the implications of that are.
Well, I'm curious, Dr. Gatan, if maybe you can help us with the idea that I remember testimony back in 2011 when we were dealing with the bill that you cited here, that frequently, if the child has shown signs of maturity, they don't even bother to try to prosecute. They look for children who are clearly under the age of 10, let's say, or 11. And is that what we're allowing here, is maybe kids who are 13 and 14 who have begun to mature, that people are getting away with this? Is that what we're talking about here? And that's something I'd like to close that loophole.
That is what we see across the country. That prosecutors, so Nicosia is led by prosecutors. Our president is a former prosecutor, our head of our law center. They're very sensitive to the prosecutors who tell them, we won't take these cases because we can't get across that. We can't overcome the burden of the age defense, of the mistake of age defense.
And have other states taken steps to
Yes.
deal with that?
Yes,
Do you
and
have
I
some
can provide you
examples?
a list of the states that have moved on this the last 5 years.
Okay. Can you email those to Michelle and I?
Yes, with
Committee?
pleasure.
That would be helpful to know, and we can take a look at their laws. I mean, we don't use that mistake of age in rape and other sex offenses.
Exactly.
Okay. Other questions for you? Well, thank you for joining us this morning. We really appreciate your testimony. It's been helpful.
Thank you so much for your public service, all of you on the committee.
Thank you. Enjoy. Are you heading to another meeting? That does, I would like to, I'd like to deal with that. I think that should not be an excuse to 12-year-old kid. I know. I don't know why that should be okay and a 10-year-old isn't. Whether we can deal with the mistake of with the 16 and 17-year-olds or we want to, I don't know. But I do think we shouldn't be giving people a free pass just because they weren't sure of the age of the child.
But Dick, are you speaking about just the 16 and 17-year-olds?
No, I'm talking about a child under the age of 16.
This would
The
take,
testimony from, and we don't have him here this morning, but I wish I had asked a question of Mr. Redmond. The testimony back in 2011 was that they do not charge kids that have matured because they're worried about that. So there are many kids who are 12, 13, 14, particularly females who mature earlier than males in many cases. And that's what I'm talking about. So these are kids under the age of 16 who are being used in sexual exploitation, but they generally will not charge because they can't, because of this age thing. Because we're giving them a mistake of age defense. That's as I understand it. Maybe Marshall or David sure want to comment on that. But Michelle has a draft amendment. I think it's been posted on our website. And
Yes, it has.
Yep,
Okay.
I believe so. I thought maybe I could just, because I can go through and it'll frame the issues. And then, the one real sticking point here is on the simulation. And then I thought we could bring in and have Marshall and David talk about it with us as well as part of your discussion. And then if they have anything to say on the mistake of age, I would love to hear it. And then I can take a look at that after this hearing, and if we want to go back to it next week. So everybody should have a copy or should be able to see up on the web. There's a very short amendment.
Yep.
And to H 936, there's 3 instances of amendment. The first one being in the definition, just adding the words at the end of subdivision G, the by, with, or on a child. Now, I think I would agree with the Attorney General's office's testimony yesterday that I don't think it's necessary, because if you look at how those terms are used in the actual elements of the crime, and you go to the other statutes, an actual child has to be involved, but it doesn't harm here. I think it's a little redundant. But I think, just to make it absolutely clear and knock out that one concern around, that we're, just to make absolutely clear that we're not talking about a virtual or simulated, child, but an actual child. So I think that's fine there, and that adds some clarity. But that doesn't eliminate the issue around whether or not this has some overbreadth or vagueness issues, or whether or not it sweeps in some constitutionally protected conduct. And I'll let Marshall kind of make his case around that. And I think Marshall and David have differing views on this issue, and I think both very good ones. So I haven't really settled on personally one side or the other there. They both raise important issues around, and the issue is whether or not if you look at that language and you say simulated, so let's assume we're talking about, it's definitely a child and it's simulated, let's say, we're talking about simulated conduct that might fall into like an L&L with a child category under the subdivision A, is that if you think about, there are movies that are out there that are, you know, in theaters, you know, and you have someone who is under 16 and there might be, you know, they're fully consenting to the production. There's people on site. This is part of the movie making. And there might be something that qualifies as a simulation of that. And that person is under 16 years of age. You know, from the language there, it's hard to distinguish whether or not that, you know, between that and then some of the stuff that we're talking about yesterday that is clearly things that you want to prohibit. And so that's kind of where the sticking point is. And and it's, you know, once you start going down into the rabbit hole of what constitutes obscenity and how do you distinguish between these two types of simulated conduct, it's pretty tricky.
Senator Baruth. Bill.
I appreciate Michelle's digging into this a little more. I guess I would say that when I look at the change, the ambiguity created by simulation isn't fully addressed by the amendment, because it could still be a simulation of this conduct on a simulated child. So I'm wondering if it would help or hurt to add the word actual before child. So it would be any simulation by, on, of the conduct on an actual child.
I think that, to me, that muddies it. I mean, if you look at the definition of child in the statute, child means any
Yep.
person under the age of, you know, under 16. I mean, there's nothing in here to me that says, that indicates that we're talking about, that it's not an actual person.
Well, I guess what I'm you know, in a worst case scenario, I'm looking at, you know, I'm remembering maybe I have PTSD from the Ashcroft days, but there was a broad-based attempt to criminalize various fictional representations, you know, things that weren't even imagistic, but that were descriptions, that were fiction stories. And so when I look at the phrase any simulation, I just find that language really troubling in how open-ended it is. And I agree that in this particular instance, I think a good reading, a diligent reading, would find simulated activity would have to be on a child. But someone could make the argument from that a pure simulation of activity on a child who is not themselves a real child, but is a simulation, might be captured under this. And
I would just, I hear you,
I'm
but
not
I
saying
just,
that-
I just
I'm not saying they would
disagree from the
win.
language.
yeah, I'm not saying they would win the case. I'm just
I
wondering
think it
if
would
we,
be a big stinker.
I think I share your concern. I think that one of my notes was there needs to be clearly simulated acts on real children. But I'm going to do something. I'm going to let Marshall and David argue it out, because I do think we have a problem with the language that came over from the other body. The any simulation may be extremely broad, which goes to Phil's point. I'm not sure how to solve the word any.
So I'll jump in at this point. I started, you know, I thought about this before, and, you know, I just hadn't really crystallized in my mind until last night, thinking about this issue and sort of the ways in which this simulation language could be applied. And I'm even thinking about it in terms of if it is simulated conduct on a real person under the age of 16. And one of the things that sort of jumped out at me last night is I was looking at my movie collection. I own a copy of the movie Kids from the mid-1990s. In that movie, Rosario Dawson was 14 and 15 at this time that the movie was filmed. And that movie certainly contains simulated sex involving a real person who was under the age of 16 at the time. So the way that I read the language of the statute, I would be in violation of the statute for owning a copy of Kids. I went looking for more recent examples of that. And the most obvious one that popped up is there was a recent movie called The Third Wife. It was a Vietnamese movie. And it was actually banned in Vietnam because it used a 13-year-old actress in simulated scenes of sexual assault. It was actually a movie describing the experiences of women in Vietnam with sexual assault. And it's an award-winning movie. It won awards at the Toronto Film Festival. It won awards at the Chicago Film Festival. And you can download it from Amazon and Hulu. And yet it very clearly includes simulated sex on a actual person who is under the age of 16. So to me, it's clear that the way that this is written is overbroad. And I think there's an additional problem. There's really sort of two related but different doctrines at stake. One is overbreadth, which is the question of, does the statute capture more conduct that is unconstitutional to prohibit than it does capture conduct that is actually constitutional to prohibit? And the other question is vagueness, because I mean, I'm a lawyer, I do this stuff, and I was looking at it and I can't actually identify what's the distinguishing principle between the stuff that the statute is intended to criminalize and the stuff like Kids or The Third Wife, which are, you know, commonly accessible mass market movies. You know, if there was some way to really draw that line with some clarity, we might be in a different situation. But the way I look at it, I don't see that line. I can't articulate what the difference is between me owning a copy of Kids and, you know, obviously at the far end of the spectrum are some of the really horrific images that the detective described yesterday. But there's a lot of area in between there, and I don't know where in there that line is drawn and how we go about drawing that line. And frankly, I don't know that there may not be a state's attorney who feels the way that the Vietnamese government does, which is to say that it is never appropriate to use a underage person in a simulated sex scene. And just like the Vietnamese banned that movie in their entire country, might choose to prosecute possession of it here in Vermont, even though it's a movie that's, you know, it's on Amazon. You can just click on it on Amazon and download it. So I think my concerns are, on the one hand, overbreadth, that this is capturing too much conduct that it's not intended to capture, and also vagueness, that it's hard to distinguish. It's hard for an average person to, really, it's hard for anyone to distinguish what conduct is this actually prohibiting and what conduct is it not prohibiting. Senator Sears, I think you were muted, but I read your lips. I think you were trying to get David to talk.
Thank you. I'm now unmuted. David, sure. I don't know if you have any comments.
I do have some comments.
But it's interesting that Senator Baruth brought up the actual child, and I had written down conduct involving an actual child. If we're thinking alike, something's wrong.
So I actually think that on that issue, Marshall and I are in agreement. I think we have considerable disagreement on some other issues, but we both agree that the arena that we're arguing in is conduct involving an actual child. So whatever way that we need to clarify that, I don't think we have any disagreement there, that the statute should be made clear that an actual child is what we're talking about, not a true simulation, or an animation or something of that nature. But within that arena, we do have a disagreement about whether or not this would be impermissibly overbroad. In other words, it would sweep up too much activity that should be constitutionally protected. And Marshall brings up some good examples around the movie Kids, or this Vietnamese movie that has caused an issue. The contrary perspective is that if you look at case law, and in particular, I'd look back to a United States Supreme Court case that decided on a New York State law, which was very similar to the one being proposed here. And in that U.S. Supreme Court case, they basically held that a statute that encompassed simulated behavior involving an actual child, and I should say it was a statute outlining simulated behavior involving an actual child, was constitutionally permissible. And they acknowledged in that case that that statute may include some content that is constitutionally protected. But even given that, they felt that it was sufficiently narrowly drawn and that the vast majority of conduct that would be swept within this was not constitutionally protected because it was obscene and was child pornography or child sexual abuse materials, as we're going to say now, that statute was acceptable. And if you look at the New York State constitutional scheme even now, they basically have what we are proposing to put in here, which is saying that simulated actions with an actual child are outlawed, are not permissible. And again, they're able to do that because New York v. Ferber, the U.S. Supreme Court case, said that they could do that, that the conduct and content being outlawed, again, was much more likely to be addressing things that would not be protected by the First Amendment. Again, these things are complicated. Marshall does bring up the reality that there are going to be cases that a court may have to step in and say, no, this enforcement action, as applied in this case, is applied against constitutionally protected material. The nature of the definition of obscenity, which basically talks about whether something has sort of societal value of various types, literary value or whatever it might be, the nature of that definition is essentially impossible, I would argue, to define with precision before the fact. And so we do the best we can to have statutes that are sufficiently narrowly drawn that it won't encompass too much behavior that is constitutionally protected. And I believe that under New York v. Ferber and under current New York, following current New York statutes, we have done that with this proposal in terms of simulated conduct with an actual child. But it is a reality of all these cases that there will be a danger that somebody could bring a case against constitutionally protected material. But the interests at stake here, which is protecting children from horrific abuse, is a sufficiently compelling interest that we believe that we should move forward, and we do believe we're on firm constitutional ground on the basis of those precedents in moving forward with this language.
Okay, so let me, as I read this, maybe I'm, not being an attorney, and maybe Senator Benning would like to jump in, but not being an attorney, sexual conduct means any of the following. And we have all the way down to G, which is any simulation of the above described conduct. What would be the harm of saying any simulation of the above described conduct involving an actual child or real children, or whatever the term you might want to use, to further define that we're talking about this throughout? A child means any person under the age of 16. So I'm just trying to understand the problem there. And Michelle, if you wanted to chime in, this is where Senator Baruth and I are in agreement.
Actually, that's exactly the spot, Dick, where I suggested to David, Marshall, and Michelle yesterday, we ought to have that tweak right in that sentence.
If it makes you guys feel better, I can add actual. So on your amendment where it says on the first instance of amendment, where you'd be adding by, with, or on a, I can add after the A, and before the child, I can put actual. and that takes care of that issue. The other issue which is stickier, is not related to the age of the child, but how do you distinguish between the movie that's on Netflix and the stuff we were hearing about from the commander yesterday? And that's the one where I think, you know, you have a disagreement on the law there.
But doesn't that exist in any of the current law?
No, because the simulation issue is, so, you know, that's, you're adding that, and that's new. So that could be the movie that Marshall was talking about, or it could be the stuff that they were talking about yesterday that firmly falls into the area of things that you want. And that's, and so that doesn't come into play unless you add simulation. And it's hard to draft in and say, well, these kinds of movies are okay, and these kinds of movies are not okay.
I don't think you can. I think your first, the fix that helps me is actual children, but I don't think you can fix the other. I think you either trust David's assurances or you go with Marshall's concern and strike the section altogether.
Can I jump in with just a quick point of clarification?
Yep.
The case that David's referring to, Ferber, that was not about simulation. That was about that was videos of children participating in actual sexual activities. It was actually about videos of children masturbating. And it wasn't simulated, it was actual. So Ferber doesn't really touch on that distinction. I think the case that comes the closest to touching on that distinction is the case that Senator Baruth referenced earlier, which was called Ashcroft v. Free Speech Coalition. And that had more to do with the question of simulated children as opposed to real children. But it does touch on the issue of simulated acts versus real acts, because the way that they explained that it was impermissible to criminalize child pornography that did not use real children is they said that what was the fact, the critical issue is that there's no such thing as child, as the woman who testified earlier today said, there's no such thing as child pornography that's not documenting a crime. It is essentially sort of an instrumentality of a crime, because in any of the child pornography that it's constitutional to criminalize, an actual child suffered sexual abuse. But in the case where it is, say, an actor and an actress, and one of the two of them may be under the age of 16 years old, and they are simply simulating sexual conduct for the purpose of a motion picture, that would not be no crime occurred there, and therefore that documentation of that, acting wasn't documenting any crime. So I think that's where the real distinction is. That's why this is a case that, even though Ashcroft v. Free Speech Coalition is not exactly on point, it's the case that comes the closest to this, as opposed to Ferber, which Ferber was just the case that first said that you can just simply criminalize child pornography. Up until that point, it had never been held that you could criminalize child pornography. And Ferber said, yeah, you can do that. And actually, Ferber gave like 4 reasons why you can criminalize child pornography. And again, they all sort of revolved around the concept of saying there's no way to make child pornography that's legal. So it's always a documentation of a crime.
Right.
So that's why I think the simulation language is a problem. And I think the other point, and it's sort of reflected in what David said, because you can listen to David's testimony and he never draws a line. He never says, here's what you're allowed to have and here's what you're not allowed to have. And I think at some point we need to know that. We need to know what videos are okay and what videos are not okay. And the statute doesn't say it, and David didn't articulate it, and I'm not sure, I'm still having a hard time myself trying to find where that line would be, and I'm not even seeing case law that clearly defines it.
Okay. Senator White has figured it out.
No, I haven't figured it
Oh.
out, but I do understand the difference here, and I think we need to be very careful, because there are a lot of groups out there who will use something like this to challenge things that really are constitutionally protected, and like the movie that Marshall was talking about it. And I think that we need to be careful that we don't give additional ammunition to those groups who are challenging free speech, as opposed to protecting children who really are being abused. So I don't have the answer. I don't know where to draw the line. I don't know how to define it. But I think that is important to remember.
Thank you. David, would you like to comment?
Just quickly to Marshall, a couple of Marshall's points, and I won't go too far down the rabbit hole of just arguing out what is essentially a courtroom argument. But with Ferber, it does include within the definition of sexual performance that the sexual conduct could be simulated. So the statutes are constructed slightly differently, and I do think it encompassed a potential simulation. I also will acknowledge Marshall is not wrong to say that it is hard to know ahead of time exactly what will be considered impermissible or not because of the nature of how courts have defined obscenity. But that is a problem that we cannot solve in this, and that I don't think will be solved until the U.S. Supreme Court chooses a different way to define it. I think that, but I would also argue that they have clearly contemplated in Ferber and in other cases that you can take steps like this to that may encompass statutes that may encompass some constitutionally protected activity, and say that it's still not facially invalid because most of what it's getting at is in fact not constitutionally protected, and that is permissible for the courts to do. And again, we would argue that the interests at stake are sufficiently high that that overbreadth, which we are arguing that it's not overbroad, but the fact that there might be some protected activity caught up in it is A, allowable, and B, necessary in this context.
Can I respond briefly?
Yep.
So this is not about obscenity. Obscenity is a totally separate First Amendment exception than child pornography. In fact, the entire point of the Ferber decision was to point out that there's some child pornography that may not be obscene, and some obscenity, some things that are obscene that may not be child pornography. Obscenity is a different test that's covered by Miller, which is a much older case. It's not, they're two separate definitions, two separate exceptions for two separate reasons. And then I think that, the other point, when David says, yeah, it may be hard to tell ahead of time what conduct is prohibited, that's essentially the definition of a law that is void for vagueness. The test that courts use to determine whether a law is void for vagueness is whether a reasonable person reading the law would be able to understand what conduct is prohibited. And I think David's as much as said that this is void for vagueness. To me, it's funny that I'm sort of taking the same side on this as the woman who testified earlier, because we wouldn't really sort of be natural allies in this. But, she identified that using the definition simulation in here presents a potential unconstitutionality. And I agree with her. I think she's right. And I think the remedy for that is to simply strike that subsection G and not try to criminalize faked or, not real sexual conduct when there was no actual sexual conduct. Because that way you are going to wind up roping in a whole bunch of conduct, a whole bunch of movies and things like that. And, I think just to sort of touch on the last of David's points, the idea that the way that this is written would encompass more permissible prohibitions than it would impermissible prohibitions. I don't know any way to actually quantify that, but I have a hard time believing that there's more people in Vermont, say, watching these really disgusting images that the detective talked about yesterday than there are watching mainstream movies like Kids or The Third Wife, or I'm sure there's, countless others where under 18 or under 16 actors and actresses have engaged in simulated sex scenes.
Well, and if I could just jump in there quickly, we have an entire category of narrative that we call coming of age films. And coming of age means different things, but one of the things it means is coming to sexual awareness prior to your age of majority. And so if you look under coming of age films, it's usually about 14, 15, 16-year-old kids having their first sexual experiences, not in an abusive sense normally, but just coming to experience romantic love in the first time. But the director or the producer of such a film is potentially using people that might be roped under the actual child part of this. And then it seems to me the depiction, as Marshall says, overall might fall into this bucket. So I think all this stems from the two words, any simulation. And then what we're trying to do is throw fencing around something that's incredibly, almost infinitely large. So I don't know, I think adding actual before child helps, but it's really any simulation that produces the discussion we're having now.
Mhm.
Can I just make one final point? And I realize that at some point the committee is just going to have to decide, but I just wanted to respond to one key thing, which is that something we need to keep in mind as we're considering this, and that I think helps eliminate some of the problems that Marshall is pointing out, or potential problems that Marshall's pointing out, is that we do have an intent requirement built into this statute, that there has to be an intent to produce unlawful, this sort of unlawful material that does not have any sort of, whatever you want to call the societal benefit, literary merit, whatever it might be. And that intent piece is really important and does limit its application quite considerably, and also provides very robust defense. And especially if you're talking about a case like a widely released Hollywood movie or a reenactment type of documentary, I think I'd be hard pressed to see a prosecutor being able in good faith to say that type of activity was a knowing attempt to produce child or share or view child sexual abuse materials. I do think that's a really important safety aspect of it. And again, Marshall and I have some serious disagreements over this, significant disagreements over this. I would also just point out that in terms of the obscenity aspect of it, I read Ferber slightly differently to necessarily contemplate. Miller is, of course, a different test than the child pornography test, but it does necessarily contemplate some of those factors in terms of what's permissible or not. But my main point here was just about the knowingly part of it, the intent part of it.
Except that the intent part of it doesn't just cover production, it covers possession. So I personally knowingly possess a copy of the movie Kids. I know that one of the actresses in the movie Kids was under the age of 16 when she engaged in the simulated sexual conduct that's in that movie. So just right there, that's gotten past the knowing part, and I could be prosecuted for my possession of that movie.
Can I would like to ask two questions of Michelle if there are no other committee questions. Okay, so one, Michelle, did the House have this discussion or did they just?
No.
Number two, what would happen if you moved simulation down to 2822A?
I'd have to take a look at all this because the definitions all build on one another. So if you look at,
I understand, but I'm suggesting that there you have no person shall with knowledge of the character and content promote a sexual performance or simulation by a child or a performance that contains a lewd exhibition, blah, blah, blah. It seems to me that there you're providing the defense that it's with knowledge, that you have the character content promoted, blah, blah, blah. This seems to me, if you really need to have simulation in there, that's maybe in a more appropriate place to talk about simulation.
I don't think that cures the issue. I think, you know, the reason why it is where it is because it's trying to define what constitutes sexual conduct, as that term is included in the definition of sexual performance. And so I don't think that remedies the issue.
All right, then if that doesn't remedy it.
I will just mention, I just wanted to mention one thing, because David was talking about an as-applied challenge and versus a facial challenge. And I just wanted to remind people, because we don't always deal with these kinds of issues, but if there was a challenge, so like a facial challenge seeks to invalidate a statute because basically all interpretations of that statute would be unconstitutional. But as applied is the circumstance where you would say, here's this movie Kids, and the statute as applied has many constitutionally, because the court is to try to read the statute in a constitutional manner if it can, and there are ways in which it can be applied constitutionally. And so they would look at the particular case and decide as applied to that particular case. So they could say, in this circumstance, as applied to kids, it's unconstitutional. However, that doesn't strike down the statute itself. So I just kind of wanted to make that distinction, because I think sometimes we use these terms and we need a little refresher about what that means.
Right.
So there's also, remember that you have a severability statute in Title I. So if you decided, you made a policy decision to go with keeping in simulation, and it was found to be unconstitutional, then that provision itself can just be struck. It doesn't take down the whole thing.
Here's nobody's commented yet on the peer-to-peer network, the Second Amendment. There's no objection to that, then.
That came from Matt Raymond yesterday, so I just plunked that right in.
Right, and there's no concern about effective on passage. So I would say that 2 out of 3 ain't bad, and we're going to look shortly at the issue of, I think the committee just has to make a decision. We can improve it by saying in the First Amendment, by, with, or on an actual child. That would be an improvement to what's already there. But the issue of simulation and the concerns expressed by Marshall and the arguments put forth by David remain. So the committee will have to make a decision on that. And then the final issue that I see is the issue of, that was raised by Dr. Catan, is the mistake of age defense. And whether we want to keep, I think that it'd be a huge jump to move 16 and 17-year-olds in to the statute at this point. It's something that maybe we would consider next year. But right now, should we consider a mistake of age defense as removing that? I mean, I would think you could use similar language that's used in our sexual assault statutes. Senator Baruch.
Question for Michelle. It's written in now as an affirmative defense, which, as I've understood it, means that it has a little additional weight when brought up in court. If we were to remove that, someone could still offer the defense, right? It just wouldn't be an affirmative defense.
Right. I think I would need to spend a little time looking at that. It's been a while since I've taken a look at that. But yes, I think, I don't, but I would think I would want to hear from the practitioners to see how they would view that playing out, and then I'll take a little time taking a look at it to make sure that I can let you guys know what the both sides are.
Yeah, because if that is the case, then I wouldn't have a problem removing it, because it does seem, the statute now does seem to elevate it as make sure you take advantage of this, which I don't think we need to be doing.
Joe?
Joe.
Well, personally, if you remove an affirmative defense, I could see prosecutors arguing that's not an issue. It's not relevant anymore. The question is the straight language of the statute. There's no opportunity to say, well, gee, I made a mistake. And because we're having this discussion and Michelle is replying, I need to do a little more research on that, I would be really leery of trying, in this day of Zoom, trying to get to a conclusion of that issue, because I'm really uncomfortable just wiping that off the books without a full going through by witnesses on both sides of that issue. The other thing I was going to do, Dick, just to try to move this along, was simply say, we've got a whole lot of questions about the simulated language in G. Personally, I would prefer we simply strike that from the bill in order to try to move forward with the rest of it.
Okay. I appreciate that. I think the vote would be simply, do you get rid of G or do you keep G? Maybe we've already made up our minds, but I thought we could wait till tomorrow, or excuse me, next Wednesday. But on the other issue, I hate to give that up at this point, since it was raised in testimony. And I'm thinking that I'm thinking of a 12-year-old granddaughter. That has begun to mature, and because of this affirmative defense, not that I have any knowledge of any kind of child porn here, but it just bothers me that, well, I didn't realize we were doing that. Anyway, so I would at least like to discuss that before our next, when we take it up next. Maybe we won't change it, but Alice?
So I'm wondering, is there any data with regard to how if that affirmative defense has been successful or not with regard to cases in Vermont?
I think that, I thought the testimony, and we could check with the Attorney General's office, I think the testimony is they just don't prosecute.
Oh, because they're afraid of losing.
They're afraid of that. So it's usually children under the age of 8 or 9. I don't know if that's correct, David, if you could check with Matt Raymond on that.
I'll check with Matt on that, yeah.
But I believe
I do know that those sorts of, as I understand it, those sorts of affirmative defenses frankly rarely get brought forward. It's an unusual case where that gets brought forward, but I will check in terms of numbers and practice.
Okay, that'd be good.
Okay. So is there anything else on this bill? So the e-filing situation, Michelle has worked with Stephanie Barrett tirelessly, moving from room to room within her house to Zoom about it. And I think we're getting close. So next Tuesday, we'll send out to the parties perhaps a solution, but the solution is that the state out of CRF funds, CRF, could pick up until December 30th, the fees. And in the meantime, we either demand that the judiciary renegotiate with the Bar Association and other interested parties, or encourage them. And that's going to be the real issue for the committee to decide. Do we demand that they do it, or do we encourage them? It gives them 3 months to solve this problem. So, and I for one, am the other would be a new bill at some point, whether this year or next year, that says you can't do this anymore. But clearly what happened was the judiciary never filed the report with the legislature that was required in the, I think it was 2014 bill that passed in the institutions committees, on what the fees would be and how it would be in there. So it's an interesting argument, but it has all the, that's where I think we'll be next Wednesday on this thing. So just kind of think about it. Alice?
So just one other issue that I was thinking about on that. In the agreement that a lawyer must sign, and I'm wondering, does the pro se filer who wants to file electronically would have to sign, it agrees that you will, if the pro se is doing electronic filing, it sounds like they have to go through it as well. And in fact, you have to, I read that agreement, I mean, you have to open up your social media to them. You have to agree to go for litigation in like Plano, Texas or something, not here. It has all kinds of things in that agreement that are pretty disturbing.
It's like those agreements we talked about a few years ago. And
Yeah.
we banned them, you know,
Yeah.
that the issue of whether you had to,
Unconscionable.
thank you,
Unconscionable.
Philip. Yeah, I think Philip reported the bill, the unconscionable terms. And, you know, here our own judiciary goes and contracts with a company that you have to mediate. And the other thing is the charge to your master charge card is automatic. You can't file without a charge to your MasterCard that they're billing you on.
Yeah, it's very disturbing, the agreement. So what
Yeah.
did we do with unconscionable terms? Where did that go?
I
We
thought
passed
we banned them. We passed it. I think
the
it
governor
got
sign?
signed into law.
Is it?
I thought it was.
Do you remember the name of the title of the number of the bill? I reported it, so
I think it
But I
has
can't remember.
unconscionable terms in the.
I'll look.
Okay.
I'll look and see right now, see if I can find it.
Well, we could, but I know we passed it out of the Senate. I don't
Yeah.
remember whether it got passed by the House and signed by the governor. Oh, what's his name would know, David Mickenberg.
Oh,
Yeah.
What's his name? Mickenberg or Micklenburg?
Mickenberg.
Mickenberg. Thank you. David Mickenberg would know.
I think by now he's either way, Mecklenburg or Mickenberg.
Yeah, right. He doesn't care.
Where is he? Did he leave the area?
Oh, no.
Oh, okay.
I think he's still in Burlington.
That's the thing. Lobbyists with this whole Zoom culture, lobbyists have vanished. I haven't spoken with or seen a lobbyist. in months.
Actually, I did hear from David a couple of weeks ago regarding S54.
Yeah.
Oh, and, okay.
Nothing.
I was going to comment on, but it was a different conference committee that I was thinking.
So the other question on that, Michelle, is does the pro se filer have to sign up with the company as well? As
Okay.
lawyers?
All right, I'll take a look.
Thanks.
One of the arguments I heard about the individual file rather than a total case file was that somebody who really wanted to push it, an attorney, could file 100 cases, and then the person would have to file 100 back. And
The what?
the attorney could file 100 motions, each one being an individual motion. Then the respondent would have to file 100 back.
Yeah.
Oh, that happens a lot in domestics.
Right.
That's what I was
So-
talking about the other day, Dick, when I was talking about lawyers who practice by the pound.
Yeah,
Mhm.
yeah,
Could anticipate your own response time ramping up considerably depending on who was actually the initiating attorney.
so anyhow, that's an interesting conundrum.
Yeah.
So Peggy, we have quite an agenda for next Wednesday and Thursday. And I may be stuck going to Albany on Thursday, so I don't know what the schedule might be.
Okay.
Right now, this crazy system. My wife has an operation on Friday. She has to have a COVID-19 test on Thursday. We scheduled her for one on Monday when there's a pop-up in Bennington. St. Peter's and Albany said that's not good enough.
Right.
It's just, I don't know how to deal, and we're dealing with an out-of-state hospital.
So Bill had the same thing when he had his cataract surgery. But
Oh,
we're only 20 minutes from Keene. So he had to
Yeah.
go over the day before and have the COVID test. And then he had the cataract surgery the next day. It has to be the day before.
has to be. And in Vermont, you don't get the results unless
No,
you're
no, no,
positive.
you would get the results if it was for a surgery.
Well,
Right,
I don't
you-
know.
I just had a constituent whose husband was having surgery in Boston, and they were one of the first surgeries opening up there, and they had to go to Boston, or
Yeah.
just near Boston for the test the day before.
Wow.
So,
Well, anyway, so that's why when I say it's tentatively Thursday, or Senator Nitka could run the committee if I'm not available, or if I'm available by phone somewhere between Bennington and Albany
in your car.
in my car. Actually, cell service is pretty good between Bennington and Albany.
Oh,
So we'll see what the schedule
So
is.
I just checked with David Mickenberg, and unconscionable contracts was signed into law.
Oh, good. So
I
maybe
just
we
sent
have
Eric a note.
maybe we have an unconscionable contract.
Yes.
Add to the pile of
Oh.
comments. What if
Add
we
to
have an
Nice.
unconscionable contract signed by our judiciary?
indeed, it's in there.
Ouch.
Yeah. Ouch.
Maybe you ought to drop the House a note on that.
Or the
That's
bar.
good catch there, Alice. I didn't realize, I hadn't read the contract.
I know, good.
Good. That just adds to the misery.
Don't mess with Vermont, they say.
Senator Sears, what days do you think we'll meet next week? Wednesday
Well,
and
tentatively
Thursday?
Wednesday and Thursday. We will not meet. I don't think, my life is scheduling around hospitals.
Yeah.
So I'm going to tentatively say Wednesday and Thursday. It may be that I'll be on a phone somewhere out in the hinterlands.
Okay.
Okay.
And our appointment may be in the afternoon, and I'll just miss the source session. So we'll see. Definitely Wednesday,
And we'll be doing the same
9:30 to put down 9:30 to 12, the e-filing, and then this bill,
Yeah.
H580, would be the issues on Wednesday.
H580.
Maybe a
Eric?
few minutes late if you're doing 9:30
Excuse
on
me,
Wednesday.
I'm sorry.
And
Yeah, I think I need to, Joe, just
Okay.
if we only end up with one meeting. No, excuse me, I'm sorry, not 580. This,
Yeah,
what's the number of this one?
936.
936.
And I'll
E-filing
do
and
some
936.
I'll do some research on mistake of age, and then I think if you can also, have Marshall and David back to kind of address policy and how they would see that playing out,
Okay.
I think
And
would be
Would you
good.
do a, after you check to make sure that unconscionable contracts stayed in, the mediation in Texas that that's unconscionable and question. So that would be another question for the judiciary. Just
Okay, I'll take a look at it.
before
Alice,
before we ask Pat the question, did she sign an unconscionable contract? I think we should make sure she did.
so I haven't read the contract. Alice, where did you, we have so much information on this. Where did you access the contract?
Terry Corsone sent it to us.
Okay, all right.
I'd say I'd find it myself, but where in the world is it now?
No, I'm sure I
look
have
at
it in the
my email.
emails. I'm trying, my printer at home is so slow, and for bigger things, I like to actually have a hard copy rather than read 100-page
too.
documents
Yep.
on my iPad. So,
It's very
I just-
long, so you'd want to go
yeah,
to. the page.
yeah, I just go into the office like every other week and print out, big cases and things like that, because my eyes can't take it all day on the iPad.
Yeah, those of us who can't go into your office to do that. Joe, it may be time for the Committee on Joint Rules to consider whether or not people should get a stipend for office.
Or what?
Office. I'm going through printers. I'm printing up stuff so I have a hard copy of things to report. There's a certain expense to all that.
Did you get that idea from Matt Valerio for asking it for attorneys? I thought that was pretty good. Get me a
No,
new computer
I
out
got
of it.
I got the idea from some House member who requested office supplies to be a now that we don't get travel and meals and overnight.
I think I'll let you ask that when you're on approach.
Oh, okay. I'll raise that when we go through legislative salary.
Yep.
Michelle, I was just thinking Michelle, you could just send an email to Terry Corsone and she could probably send you the section right
Sure,
there.
I probably have it in my emails. I'll check, and if not, I'll follow up with Terry.
But it is a good point, Alice. Thank you. With that, we'll see you all at 1,
That's right.
thereabouts.
See you in a bit.
Okay,
See you in a
bye.
bit. Thank you all.
Bye.
Bye now.
Peggy.
Bye.